It's great to be here. Planetizen is my homepage. It's a great way to keep abreast of what's going on in the practice of planning around the country, including sometimes legal issues. So I'm gratified and honored to be here this morning, and I appreciate all of you being here to hear about the legal issues associated with writing and drafting zoning and development codes. I'll start by mentioning several things. One is I want to preface just about every single thing I'm going to say this morning with the phrase generally speaking. We're here in Southern California. California has a very unique set of land use enabling legislation and land use laws. I'm targeting my presentation to all 50 states in the country. So the things I'm going to tell you are the general rules, the rules that you're likely to see and somebody who's listening to this presentation is likely to see in their state. But before you make big decisions about codes that you're writing, you should check carefully on the state of the law in the state that you're in. The second thing that's very important to note is that codes are laws. Codes are laws, and if you don't believe me, write an illegal code and see what happens. Codes are not marketing brochures, they're not planning policies. Once you write a zoning ordinance or any other kind of land development code, a form-based code or anything else, it becomes the law of the land in your community. So today I'm going to focus on what a code is and what a code does, different models of enabling authority around the country, the constitutional issues that are unique to drafting and preparing development codes, and also whether and how courts care about how you actually write your codes. So those are very important things. I've been doing this for close to a quarter of a century, which to most people is a pretty long period of time. It's the majority of my practice as an attorney and also as an AICP planner. What we're going to learn today in the course are, first of all, permissible areas of regulation, how to identify in whatever state you're in, the things you can regulate, things you can't regulate, and even for things that you're allowed to regulate, and development standards, metrics, and so forth, how you identify the parameters of those. I'm going to talk about how to avoid constitutional landmines, hidden things that can blow up under your feet unexpectedly if you're not careful about how you write a development code and develop the standards that you're dealing with. And also how to balance the goals of writing a code in a precise enough manner that people know what's expected of them versus retaining discretion for uses that really need some sort of case-by-case review. It's a tender balance that every community walks as they develop codes, zoning ordinances, and so forth. So in Chapter 1, I'm going to talk about what codes are and what role they play. And as I mentioned earlier, codes are laws. They give you the authority as a planning official to ask developers to do things, to tell people they can't do certain things with their property, or to attach conditions to approvals that are required in your community. So I'm going to talk about what a code is, what codes accomplish, and the difference between codes and land development policies, such as a general plan here in California or a comprehensive plan in most other states. So first of all, a code is a law, as I mentioned. Again, as with traffic violations that are defined in a municipal code and other types of violations that you might identify, they set parameters. Developers, property owners who are developing property in your community or using buildings or structures or land for something have to abide by the laws that you've established in your code. And codes do several things as a law. They set out substantive rules. For example, the uses that are allowed in a zoning district, the setbacks that are required, maximum, and sometimes we'll talk about form-based codes later, minimum building heights, and so forth. So those are substantive rules. They also set up procedural rules, which are the processes that landowners and developers have to go through to get a property entitled, to use their property the way they want to use them. And as you often find, if you've been through a comprehensive code update, codes are often mediations. Comprehensive plans are often very aspirational. They talk about what a community wants to be in 20 years. Some of those policies are just fine with landowners, property owners, developers, neighborhood groups. Some of them aren't. And as you go through a code update process, you will find quickly that different stakeholder groups have different ideas about how those policies are implemented, and sometimes whether those policies need to be implemented. And the code mediates the interests of those groups, because we have in the United States a democratic form of government. The codes don't become law until they're voted on by your legislative bodies, and in the course of going through that process, you have to mediate the interests of all of those groups. Codes are also dictionaries. They contain language that isn't generally understood often by the general public. Language about things like non-conforming uses, even things like setbacks, even things like building height, which you have to define where the building's measured from and where it's measured to, and you turn to the code to define what those things are. And I mentioned the code is a law, and sometimes codes tell property owners and developers what they can't do. They can also be enablers. In communities where you have tight zoning regulations, for example, you can create special overlay districts or special types of development that has preferred processing procedures or streamlined development approval processes that makes the things you want to see happen in your community easier to do. So it doesn't just tell people what they can't do. A good code will also lay out a framework and a good instruction manual for the things that your community really wants to see happen. So it's not just a dictionary, it's not just a list of things you can't do, it's also an enabler, and it's also a bridge from your comprehensive plan to what happens on the ground.